Good evening, everyone, and welcome to the VYAP event on climate change and international law, evolving frameworks for the resolution of climate-related disputes. My name is Sunita P. Advani, and I'm the founder and chair of Singapore Very Young Arbitration Practitioners, or VYAP. I'm also an arbitral assistant and tribunal secretary to Michael Lee, an English arbitrator member of 20 Essex. We're very excited to have you all here for what promises to be a very interesting panel discussion on a very timely topic and an important topic. We are truly grateful to our exceptional panelists for taking the time to join us today out of their busy schedules. And we would also like to express our appreciation to our generous sponsor, Herbert Smith Freehills Kramer Prolegis Alliance. Our first panelist is Elodie Dulac, who is a partner at King & Spalding in Singapore, joining us virtually. Our second panelist is Ashwita Ambast, and she is a senior legal counsel and the Permanent Court of Arbitration representative in Singapore. Our third panelist is Ashley Ong, who is a deputy senior state counsel in the International Affairs Division of Singapore's Attorney General's Chambers. And our fourth panelist is Dr. Alain Grieder, who is a senior associate at Schellenberg, Wittmer in Singapore. And last but not least, our fifth panelist is Reshma Nair, who is a senior associate at Herbert Smith Freehills Kramer Prolegis Alliance. So before we begin, I'd like to highlight that we will have an audience Q&A round after the panel discussion, sort of during the last 10 minutes of the event. And for those attending in person, you can submit your questions by Slido, scanning the QR code on the flyer. Alternatively, you may raise your hand and ask your question verbally during the audience Q&A round. For those attending virtually, you can submit your questions via the Q&A function on Teams. With that, I'd now like to start with our first question, which is for Elodie. So when we talk about climate-related disputes, what kinds of disputes are we actually referring to, and through what fora are they currently being resolved? Elodie, grateful for your thoughts.
Hi, good evening, everyone. I'm sorry not to be able to be here in person. So that's quite a broad question. In the ICC report on climate change disputes, climate change disputes are defined as arising out or in relation to the effects of climate change and climate change policy, the UN Framework Convention on Climate Change, and the Paris Agreement. Where we see these disputes, and there'll be more and more, where we see these disputes arising is contractual disputes, which can go both to arbitration or litigation, depending on their clause, because more and more you're going to have contractual terms, obligations relating to climate change, which can be reps and warranties, disclosures of gas emissions. So these clauses will be enforceable and in the forum chosen in the contract. You will have, I would say, classic construction disputes, because you're going to have for these new projects in the renewable sector, you're going to have construction projects, EPC contracts, again, where they will be heard, whether it's litigation or arbitration. In my experience, it's mostly arbitration, but ultimately it's the chosen forum in the contract. We have seen in a number of countries, and there are more and more, court litigation. So there are court litigation which are between parties, and for instance, to give an example, there has been greenwashing litigation, which means companies portraying they're taking sustainable or green initiatives, which they are not really taking. A recent example is in Australia. Before Australian courts, a case called Mercer, where basically that company represented to its investors the portfolio in which they were investing was a sustainable portfolio not involving fossil fuel company. It turned out there were fossil fuel companies in the portfolio, and this was the court found it was a misrepresentation. more high profile. I think a lot of you may have heard about cases, especially in Europe, before the courts against governments, alleging, so mostly NGOs, individuals, suing governments for failing to meet their emission targets. So one of the landmark cases, which is very well known, is against Shell. Sorry, that one was against a company. There was one in France where the French government was sued for not meeting its emission targets, and the court actually found that the French government didn't meet its emission targets and had to take remedial measures, which the government took, and the court found it had taken. You have cases against company. That's where I come to the Shell case in the Netherlands, basically suing companies in relation to climate change. So for Shell, it's an NGO which alleged that Shell was obliged to contribute to combating climate change. The Court of Appeal overturned the lower court decision, but the Court of Appeal still found Shell was obliged to contribute. So that's the kind of litigation. There has been litigation in English courts, in Korea, in a number of countries. There'll be more and more, where either against companies or against government for failing to meet emission obligations. So it's kind of a broad brush, and we'll go. And of course, and we'll go into it in detail after. The flip side is the investment treaty cases by investors, which are affected by the regulatory changes to meet climate change objectives. So that's a broad brush overview, and we'll go in details in many of these aspects during this session.
Thank you, Elodie. I would now like to turn to judicial pathways and would like to pose the next question to Alain. In relation to public interest climate litigations around the world, what sort of claims have been brought against states and corporations? Which arguments were made and which claims were successful?
Yes, thank you, Sunita. We have already heard a little bit of an introduction from Elodie. I'm going to go into a little bit more details here, but maybe let me start by saying this. Public interest climate litigation is usually driven by the goal to influence the behavior of a state or of a corporation. And because of that, they're usually brought by NGOs or by environmental interest groups. And I think this is important to keep in the back of your heads when we talk about individual cases. And they're also brought against the background of the Paris Agreement. I'm not sure if everyone knows what the Paris Agreement is, but the Paris Agreement basically is an international agreement which is binding on the states that have joined it. And it obliges the states to reduce global warming in a very broad sense. So in my view, you can categorize the claims that have been brought in this area in three broad categories. The first one is claims that have been brought against states to trying to compel the states to either introduce new legislation or change the existing legislation. And there have been a lot of cases. One of the major cases, in my view, was the case of the Urgenda Foundation against the state of the Netherlands from 2015. I'm not going into the details of this case because we don't have the time for that. But basically, this is a case, when you read it, you can see in this case, the state has been ordered by the court to actually adopt more ambitious emission reduction targets than they initially wanted. This is usually a case that the state is doing somehow something, but the claimants, they think it's not enough to reach the goals of the Paris Agreement, and that's why they're suing them. The case I really would like to focus for a moment is a New York case from 2024 from my home country, Switzerland, the case Klimaseniorin against Switzerland. So basically, the claimants were a group of elderly Swiss women. All of them were at the age of 75 or older, and they argued that their group of people are more heavily affected by heat waves, which are a consequence of climate change. And because of that, the Swiss government should have implemented certain measures to protect them. And so they sued the government to compel the government to introduce certain measures. All the Swiss courts have declined this case, mainly on standing grounds. We will get into the details a little bit later on, but basically the court said, well, this is not really a legal issue. What you want is a change in legislation, and this is a political matter. Go to the legislator. The case then went up to the European Court of Human Rights, and the European Court of Human Rights granted the claim. And this case is very interesting because it was the first time that the European Court of Human Rights explicitly held that everyone living in a country which is a member state of the European Charter of Human Rights has a right derived from Article 8 of the European Charter of Human Rights, which is the right to respect for private life and family life, a right that your government is taking measures to protect you against consequence of climate change. So this is, in a very broad sense, the first category of claims, how I see it. The second category would be claims which are brought against corporations to trying to influence the corporation to change their behavior or to introduce certain measures. And here, this is also something we have briefly heard from Elodie. The leading case, in my view, or still one of the most important cases from the Netherlands, the Milieu Défensiv against Shell. And this NGO has sued Shell and has asked the court to order Shell to reduce their greenhouse gas emissions by, I think it was 45% by 2030. So it was an enormous reduction over a relatively little short amount of time. And the claimant argued because of the goals of the Paris Agreement and some new insights, some new findings based on climate change science, they have a duty of care to reduce their greenhouse gas emissions to a pretty big degree. The court granted the claim, and at the same time, the court acknowledged that there is a certain kind of horizontal effect of rights derived from the European Charter of Human Rights. It went then up to the Court of Appeals, and the Court of Appeals set aside the judgment. But the important thing is the court did not say that Shell does not have obligation to reduce their their greenhouse gas emissions, but they simply said, as far as I understand it, they said you cannot translate the goals of the Paris Agreement directly to private companies because usually it's for the states have to implement it. So they have set it aside, but still it was an interesting case. And now quickly to the third category of cases. In my view, those are cases in which corporations have been sued for damages. The leading case, in my view, here is the Liuya case from Germany. This is a farmer from Peru, and he sued the biggest German energy company, RWE. He still lives in the Andes in some mountain village, and he was arguing that the greenhouse gas emissions produced by RWE, this German company, contributes or causes a glacier right next to his mountain village to melt. And then this was building kind of a glacial lake, and eventually this lake will overflow and will destroy the village. So he had to build some flood protection measures, and now he wanted compensation from RWE. And the court of first instance dismissed the claim. He said, well, we don't really see how this is only the fault of RWE because there are so many companies which are emitting greenhouse gases. So why should we order RWE to pay and not everyone else? So they dismissed the claim based on that, but then it went up to the Court of Appeals, and the Court of Appeals said, no, this is actually not a valid argument because there are other companies which are also emitting greenhouse gases doesn't mean that the individual company cannot be made liable. And in principle, the court said RWE can be held liable for this, but they still dismissed the claim based on some technicalities of the specific provision of German civil law that they invoked. Basically, I think the requirement was that the damage was happening within 30 days. And the judges even flew to Peru and looked at the glacier and said, yes, this glacier will melt, but not within 30 days. That's why we have to dismiss the claim. So, and I stop it here.
Okay, thank you, Alain. So what are the common challenges involved in attempts to use legal proceedings to compel states and corporations to adapt activities in response to climate change and in furtherance of the public interest? Alain?
Well, there are a few challenges. Maybe I'm going to start with jurisdiction. Mainly in cases in which you're seeking damages, they're usually based on tort. And in tort cases, jurisdiction can be at the domicile of the injured party or at the place where the damaging act was performed, or at the place where the effect of the damaging act was occurring. And now when you think about it, the place where the effect of the damaging act occurred in climate change cases can be basically anywhere in the world, because there can be a company here in Singapore emitting greenhouse gases, and then somebody in Germany can argue, well, I suffered the damage because of climate change, and I'm sure this company in Singapore somehow contributed to it. So this can be a challenge, but can also be an opportunity, because you can look for the best forum to bring your claim, which is probably in the Netherlands, based on the previous cases. So this is an issue. The biggest issue, in my view, is causation, because especially in those tort cases, you have to prove that there is a causal link between the emission of the greenhouse gases and the specific damage that you want to be compensated for. And the problem is, it's very hard to prove that this specific company that you're suing was responsible for exactly the damage you suffered. And there is something like attribution science, which is scientists, they can actually calculate the total amount of greenhouse gases which were emitted over the course of time since the Industrial Revolution, which I think started 1750 until today. And then in the second step, those scientists, they can calculate what is the amount of greenhouse gases attributable to this company from the total amount. And then usually, I think in this case in Germany, it was 0.5% or something, so a very, very small amount. And based on this, then you have to see how you can attribute your damage to this company. And this also leads into another issue, which is the amount of damages, because let's say you suffer the damage of 100,000 Sing dollars, then you have to somehow prove that you have to be compensated for everything and not only for 0.5% of that, because this is what the causation would say. I think I stop it there. You want to talk about standing, Reshma?
Well, I think Sunita's question, well, hello, everyone. I think Sunita's question was, what are the challenges and opportunities? And just before the panel started, I said to her, well, it's actually quite difficult to identify opportunities, but I'm going to try anyway, because why not? And maybe what I'll do is try and reframe that fundamental hurdle that you've just mentioned on causation. And if I pick up on that, as Alain's just explained, the biggest difficulty is trying to show how the emissions, particular emissions of a corporation, can be tied to, say, an extreme specific weather event, right? But maybe we can think of this as an opportunity in terms of how we frame our cases. So I think there's one bucket of cases I'd like to think of as forward-looking cases. So the Klimatsnorinen case is a classic example of that. The Swiss ladies didn't say, you should stop the heat wave from happening, or you have caused this heat wave, which we're suffering. They tried to tie the Swiss government's obligations to the fact that they need to mitigate the effects of climate change. They tied it to the Paris Agreement. And so they didn't have to prove, right, that these lacking laws, in their view, have caused the heat wave. They just tried to mitigate the effect. Same with Milieu du Foncier. They effectively just said Shell needs to reduce its emissions by 45% or whatever the number was. So that's the forward-looking cases where you try and step around the causation issue. And then if you don't step around the causation issue, I suppose the RWE case, which he's just set up for us, is great because, like he explained, the Peruvian farmer was suing RWE. He said, you need to pay for about 0.5% of my flood protection costs. Why 0.5%? Because RWE has historically contributed about 0.5% of the global emissions. And as you mentioned, the lower court, of course, denied this. But then the higher courts in Hamm, I believe, in Germany, accepted, and I'm now focusing on the causation issue, accepted the probabilistic science evidence, right? So he didn't have to show that RWE's 0.5 emissions have caused the glacier melt. The court was happy to accept the IPCC modeling, which showed that, one, of course, as also following from our agenda, that if you have contributed emissions, you are likely contributing to climate change and the effects of that. You can't argue that it's just 0.5% and so it wouldn't have caused anything. Drop in the ocean argument doesn't work anymore. But more importantly, if you could show on the IPCC modeling that there was a certain percentage chance that these emissions would have caused the flooding, then you're good on adequate causation. And as you explained, the reason why it failed was because the farmer couldn't show imminent threat or imminent harm. And there's a lot of criticism around that as to what the court should have accepted as evidence. But in terms of the opportunity, then you can think of framing your case, we're all soon to be practitioners, if not already practitioners. If you can think of framing your case as not these emissions have caused this typhoon, but rather these emissions have caused a greater percentage chance of this typhoon or the effects of the typhoon to have worsened, I think we're on better ground, with some thanks to the RWE case. And I use the typhoon example very specifically because, as some of you may know, Shell is facing another case. Just from December last year, communities in the Philippines are suing Shell for the worsened effects of the typhoon. And I'm not privy to that case. I don't have the arguments, but I'd be really interested to see whether they rely on probabilistic evidence rather than saying, well, Shell's emissions caused this typhoon.
Thank you, Reshma. I'd now like to turn to treaty-based climate dispute resolution, and in particular, the Energy Charter Treaty. What kinds of climate-related disputes are being brought under the Energy Charter Treaty? What sorts of parties have been involved in such arbitrations? And how has the energy transition reshaped both claims and defenses in these cases? Elodie, grateful for your thoughts.
Yes, thanks. Well, I'll start by RWE, which is the company which has contributed a lot, apparently, to climate change litigation. One type of investment treaty disputes we've seen arising of climate change is in relation to measures by states, basically to phase out or ban mostly fossil fuel or as measure to implement the climate change objectives. And investors have been affected negatively by these measures and have brought claims against government, not to revoke the measures, but to get compensated for the impact of the measures. So RWE sued the Netherlands, and it sued the Netherlands under the Energy Charter Treaty in relation to the Dutch government decision to phase out coal power by 2030. In compliance with its obligation under the Paris Agreement. Ultimately, the case was withdrawn, but for jurisdictional reasons which are unrelated to the climate change issue. But that gives an idea of the claims there can be when there is a phase out as a consequence of climate change objectives. And then you mentioned the Spain-Italy cases. So there have been probably above 60 investment treaty cases against Spain, mostly, but also against Italy in the renewable sector. Both countries enacted incentives for investors to invest in the renewable sector. So if we take Spain in the photovoltaic, solar sector, the government, and that was the kind of the dispute in the cases, the government basically made representations as to tariffs to incentivize for investors to make investment. For investors invested, and then after that, the government rolled back the tariffs because it was too much of a burden on the public budget. So bona fide decision to roll back the tariffs, which has given rise to a wave, dozens of claims against Spain and Italy, which for most have been successful. Most of these claims, the vast majority, used, most of them, the Energy Charter Treaty, but even when it was other treaty, the hook was fair and equitable treatment. The obligation of the state to guarantee to the investor its investment fair and equitable treatment, and in particular the subset of fair and equitable treatment, which is legitimate expectations. So the argument was, by giving these incentives, in terms notably of tariffs, for investors to invest, the governments have created legitimate expectations that these tariffs would be provided and would remain for the duration which had been represented. And there, I mean, these cases are very interesting because first, like you have a dozen of cases on the same type of measures, but the way tribunals approached it, basically it's a regulation to relating to climate change. It's a general regulation, which is later changed. How, and that affects investors, how does that give rise or not to claims? Which is very sensitive because you have public purpose, it's not disputed, environmental, for environmental purpose regulations. So these cases are relevant beyond Spain and Italy. Basically, whenever you have this kind of problematic, which is a regulation change for climate change purposes, you run into the same issues as in these cases. Tribunals have adopted a range of approach. Some tribunals have been a few have been very restrictive. If you look at the Sharon case against Spain, one of the earlier one, under the ECT, the tribunal rejected the claim. It found that legitimate expectations cannot arise from an incentive scheme directed at a group of investors, that you cannot convert a regulatory standard into a specific commitment by the state, that this would be an excessive limitation on the power of states to regulate in accordance to public interest. So that was one end of the spectrum. Other, more often, tribunals have taken a broader approach to legitimate expectations and have considered that you do not need a specific commitment by the state to that specific investor, to the individual investor, for the legitimate expectation to arise. And for instance, if you look at the Cube versus Spain case, which was enforced at the end of last year in the US, the tribunal noted that in highly regulated industries, incentive schemes are plainly intended to create expectations upon which investors will rely. A recent example of that approach, you can look at the Crook versus Spain case, which all these cases are available online in free access. And then you have an even broader approach, which is to read into the ECT, and that could also work with other fair and equitable treatment clauses in many like so-called first generation treaty where there is no restrictive language. So it's to read in the fair and equitable treatment clause an obligation of stability of the legal framework by the state, and to find that the state has an obligation under the treaty to provide fundamental stability. So some changes to the regulatory framework are permitted, but the investor, the state cannot drastically, abruptly, unreasonably revise the regime on which the foreign investments depended. So you see that recently in a case which was not against Romania, but the same like renewable issues under the ECT, where this kind of approach on like basically regulatory stability and the state cannot just wipe out the regulatory regime governing the investment. And the last example, like of these cases, right, is like a case about a ban broker against Italy. It was in 2022. You had so the company had a concession agreement. Then Italy passed a law banning offshore drilling projects, which this concession agreement was for. So as a result, Italy denied the permit for exploitation under the concession agreement. The tribunal found in favor of the investor, and here it's interesting, it found it was expropriation. The tribunal found there was an expropriation because there was a complete deprivation of the claimant investment through its concession agreement. So you have like most cases will be fair and equitable treatment, legitimate expectations, because like in the Spain cases, like the investment is still is not still operating. It's just the revenues or the financial viability is severely affected. If you have the ban cases like the one I just mentioned, like the investment, there is also a ground for expropriation claims. So again, these cases are kind of illustrations, and there are like dozens of them, and these are the arguments we'd expect investors to try to make if there is regulatory changes to meet climate change objectives.
Very insightful indeed, Elodie. Thank you. Reshma?
I'm not sure how much more I could add to that really kind of comprehensive coverage, Elodie. So maybe I'll try to bring us to a discussion on indirect expropriation. So in terms of the buckets of cases, I think you can split it, all the cases that Elodie's just mentioned, you can split it into about two buckets. One are your fossil fuel emitters who are challenging the phase out. Your second bucket would be your renewable investors who are crying about stranded incentives, right? Who say, well, I thought there would be this rate of return. I thought the carbon price would hold at this level. I need that. And I think the commonality between all these cases that we've heard is very much that they're predicated on long-term expectations, right? Which goes to the FET point that Elodie was mentioning. But the other way that we could look at it is, in addition to the fact that it's just long-term, you've got a legitimate argument for legitimate expectations. One of the key battlegrounds as a result is the stabilization clauses in these treaties. So particularly for your legacy treaties, they tended to be quite claimant-friendly and had freezing clauses in there. Today, and we're talking about practice not necessarily in the context of an active dispute, but also pre-dispute. A lot of your newer treaties tend to have explicit carve-outs as a result, and I'm sure Ashley will know more about that. But you'll have explicit carve-outs to kind of avoid those types of disputes. So I'd say definitely lots and lots of stabilization clause disputes for all of us in the future as well. If I had to talk about a trend in terms of arguments, I think parties are so much more sophisticated about their arguments now, which is where I wanted to come to indirect expropriation. I think that claimants are almost always very clear that they want to run an indirect expropriation case. They're very quick on running their DCF analysis. They will have that set up. They'll know and present to the tribunal that this was the DCF before the change or the carbon ban or whatever it was, and this is my DCF after. And they're very quick about arguing sole effects, which means it doesn't matter what the state's policy incentives were or justification was. Look at the effect from my DCF valuation. It has deprived my investment of about 90% or whatever the value is. And I think in the same way, states are also engaging with this expropriation type argument. They are pushing the narrative of justification and policy a lot more. They also have a lot more in their arsenal, especially now as we discuss more and more of these cases. They don't only have the Paris Agreement. They now maybe even have the ICJ advisory opinion to rely on, or the jurisprudence from the ECHR to argue that, well, your policy justifications have broader remit, as Elodie's just explained to us. So I think indirect expropriation is where I'm seeing a lot of these types of disputes carry through. I don't think, do you have another minute or no?
Sure.
I was just going to, I was thinking about this as we were speaking. One of the examples that I was working on recently was, and this is a really practical one. So the state knows that if it implements this energy transition policy, it's going to get hit with these arguments of breach of stabilization clause or FET. And so what it's tried to do in a pre-disputes avoidance stage is transition its transition. And so it started to first think of removing the private foreign investors from this specific industry. We can call it nationalization, but that's basically what they've done. They've offered buyouts to private investors, having first announced that they are going to move in this policy direction, etc. And so they've taken a few steps, which I would say would put them in really good stead in the future if there is a claim for lack of compensation eventually when, say, the licenses are revoked or no longer renewed, because they've put in a lot of effort in trying to anticipate that. I only mentioned the point not to say that, well, we might have treaty disputes around that, but people are also learning from these disputes. And so the nature of them will also change over time.
Very interesting, Reshma. Thank you. Our next question is for Elodie. what have been the broader repercussions of ECT climate-related awards for states, investors, and treaty reform?
So for states, it's been like treaty reform, as what just mentioned, is the BIT drafting becoming more refined and more evolved, and seeing now express provisions relating not only to the environment or public health, but to climate change. So one example, and as you mentioned earlier, the Energy Charter Treaty has been kind of like a favored treaty by investors bringing climate change related claims. That has led to kind of a fallout. So on the one hand, a number of countries have withdrawn from the ECT. That's the case of a number of European countries and the EU. And then for those who are still party to the ECT, there has been a revision of the ECT, which is has not been ratified yet, but assuming it will enter into force, as express language on climate change. So there is a new article on the right to regulate, for instance, which reaffirmed the right of states to regulate, including for climate change mitigation and adaptation, and which expressly states that except in rare circumstances, these regulations, including with respect to climate change mitigation and adaptation, do not constitute indirect expropriation. So adding express language. Another interesting example, because it's a continent-wide treaty, is in Africa, the AFCFTA investment protocol, which would comprise most African states. It has not entered into force yet, but when it does, it will be continent-wide, and it has a provision saying it will replace, the states will have to terminate their intra-Africa BATs. So that will be really the broader multilateral treaty in that sense. It has also added express reference to climate action and the right to regulate for that purpose, expressly stating that a breach, measures by state to comply with their international obligations, so that can include Paris Agreement, should not constitute breach of that protocol, that investment protocol, which is a treaty. And importantly, because one of the difficulties by states has been how to bring counterclaims, or how to, in the investment treaty context, how can state raise climate issues other than as a defense, like a public policy defense. The AFCFTA investment protocol, and we see it now in newer treaties, incorporate express obligation of investors, which means the state could sue or counterclaim against the investors for breach of these obligations. And these obligations include climate change or sustainable development obligations. So that's a very interesting development, because that's kind of has been the gap in these disputes where states didn't have really a basis to counterclaim in a BIT case against investors. So kind of overall a rebalancing. Having said that, in Asia, you still have mostly what's called first generation treaties, which do not have that language, which still has a broad fair and equitable treatment clause. So from the investor perspective, there is like, I think, increased interest in what's called treaty structuring or treaty shopping, which is making sure that their investments will fall within the scope of an investment treaty, which will not have these restrictions, which will still offer the broad first generation restrictions.
Thank you, Elodie. So our next question, could you please share with us your thoughts on the implementation of Article 6.2 of the Paris Agreement, as well as the Paris Agreement's draft conciliation annex? Ashwita, grateful for your thoughts.
Thanks, Sunita, and thanks to SG VYAP for having me, and for all of you, for being here. I may start with the conciliation annex first, maybe with what exactly the conciliation annex is. As several of you may know, under UNFCCC, as well as the Paris Agreement, which Alain in his intervention, in order to resolve disputes relating to the interpretation and application of these agreements, states, if they have so agreed, can either opt for judicial settlement before the ICJ, or alternatively to resolve their disputes pursuant to arbitration under procedures to be agreed by COP. However, what's important is that the parties to the dispute should all have opted into one of these procedures. And if they haven't, then these procedures cannot be resorted to. What happens is there's a resort to a default compulsory conciliation procedure. And then what is said is that that process should be run in accordance with procedures agreed by COP as soon as practicable in an annex on conciliation. So that's really what this conciliation annex is. Very few states parties have actually submitted or opted into ICJ or a judicial settlement or into arbitration. I think there have been 4 declarations so far, of which only, I think 3 have referred to arbitration and 1 has referred to the ICJ. So there's very little purchase, which really highlights the importance of this process of conciliation in the annex, because were a dispute to arise, it's most likely that this dispute will go to conciliation. And notwithstanding the fact that UNFCCC was finalized in 1992, COP has not yet actually agreed these procedures. So that's really quite an open, long-standing gap in the entire dispute settlement framework of the UNFCCC as well as of the Paris Agreement. What has happened, however, is that that ICA, the International Council for Commercial Arbitration, has set up a panel of experts. Many of the names on this panel will be familiar to you. It includes people from AGC, such as Natalie Morris-Sharma and others. And what this panel of experts has done is in 2023 has published a draft conciliation annex. And the purpose of this annex is to create something that could serve as a guide to COP, a sort of a blueprint for what this conciliation procedure could look like. And I guess it's also important to perhaps address why conciliation. So why is it that this default has been made to conciliation? What is special about that procedure? As many of you who may have encountered conciliation before would know, it's a very flexible procedure. And the reason why it is so helpful in this sort of multilateral dispute settlement context is because the aim of the procedure is to be constructive. It's looking for amicable dispute settlement, to enhance trust, enhance communication, improve the relationship between the parties. And it has an ability, because of its flexible and open textured framework, to be able to account for various socio-economic differences between states that might end up being parties to these disputes. So that's really the interest in conciliation. And the other interest is also in its procedural flexibility. Because of the kind of disputes that might arise under UNFCCC or the Paris Agreement, it is important for any dispute settlement framework to be able to account for the fact that multiple states might be parties to these disputes. They may have different interests in the dispute, that there may be a certain amount of technical complexity that might require expert intervention, maybe on the conciliation panel, maybe otherwise. There's also a huge interest, I think, in making sure that there is open dialogue, which is possible in a conciliation, because you don't have the same kind of rules about ex parte communications and so on and so forth that might govern judicial settlement or arbitration proceedings. So this is really the interesting conciliation, and why there is a group of people who's looking to develop this annex to make sure that the gap is filled, and that if a dispute arises, there is something available that COP can work with. The draft annex that was prepared by the panel of experts isn't public, so it exists, but it's not out there. But I would expect that it would deal with a lot of the questions and procedures that are currently incomplete and aren't referred to in the agreements that we've been talking about. So it should be addressing this balance between confidentiality and transparency, how the procedures are run, how exactly you would moderate the intervention of third parties in this dispute, and so on and so forth. And what I do know is they've also agreed to PCA administrations. These disputes will be administered by the PCA, probably because we've administered several interstate conciliations before. But in terms of the way forward for this annex, what would have to happen is that it would have to make its way back to the COP agenda, which I've understood is not really a very straightforward thing, because there are many things that COP is considering, and then then they would have to perhaps use this annex as a guide and then develop something that they can agree to. On your second point, sorry, on your first part, the first part of your question on Article 6.2 of the Paris Agreement, I don't know how familiar people are with Article 6.2, but essentially this provision concerns the trading between states of carbon credits through what's known as ITMOs, or internationally transferred mitigation options. So the premise of the article is essentially that overall global mitigation is aided if there can be financial support from buyer countries or more financially well-off countries to countries where there are projects, but there may not be funding for those projects. So that's essentially the philosophy. So if I was to simplify it, the Paris Agreement, it requires states to meet certain NDCs. As states continue to decarbonize their economies, they continue to engage in these sort of mitigation projects, further mitigation becomes progressively harder and more expensive. So all the low-hanging fruit is gone. It's harder for states to, and more expensive for them to achieve the same outcomes because they've done what was easy already. However, what Article 6.2 allows is for buyer countries to finance these mitigation projects that are happening in other host countries, because the comparative cost of mitigation of those projects in the host countries would be lower than what the buyer countries would otherwise have to do. And those projects probably wouldn't otherwise get off the ground because there isn't that financing in the host country. So it's sort of a mutually beneficial outcome for everyone. But what's important, and that's the concept of the ITMO, is that there is a corresponding adjustment. So the buyer country essentially gets the credit for the work on the project, and it goes towards their NDCs. And to prevent double counting, the host state in which the project is taking place cannot count that project towards its own NDCs. In terms of the legal framework, the framework for this entire the operation is quite decentralized. I think it's governed by a multitude of bilateral and multilateral agreements called implementation agreements. And what those agreements do is they establish rules, governance frameworks, and essentially they govern how this transfer of ITMOs happens between countries. And over time, what's interesting is that there have been certain countries that have emerged as buyer countries that are more likely to be in that position. Singapore is one of them, but also Switzerland, Sweden. Then there are a number of examples, and there are equivalently a number of examples of host countries that have emerged over time in the practice of Article 6.2. And there are a host of implementation agreements. And the reason I've gone into this background is because they also have dispute settlement provisions, which are interstate dispute settlement provisions. And they're all quite different because this is such a dispersed and decentralized sort of process. Some of these agreements really only provide for negotiation or other sort of amicable means of dispute settlement. Others tend to refer to the mechanism for dispute resolution in UNFCCC, which we've already talked about as having some gaps that are yet to be filled. I will stand corrected completely by Ashley on this because he's definitely the expert on implementation agreements. But Singapore, I know, has entered into a number, I think 10 implementation agreements, of which I think 8 provide for binding arbitration as a possible option after sort of the internal joint committee procedure has been completed. So this is really another area, I would say, possible interstate dispute settlement in climate change that I would say is of growing interest because so many more of these agreements are being concluded. I think in Singapore, it's all happened in the past few years. And they're rapidly growing in number. I think I'll leave it there. Thanks.
Yeah, thank you for that. Elodie?
Yeah, I mean, not much to add, just to say that this is like the interstate dispute resolution for the Paris Agreement. And as we alluded to earlier, for companies, individuals, NGOs, or investors, the remedies will be outside, and it's the positive remedies to try and force states to comply with their obligation of the Paris Agreement are likely to be mostly in court, as we've been seeing, and then the new treaties with their new drafting will give the space to states to actually adopt the measures to comply with their obligation without a lesser risk of being sued, let's say.
Thank you, Elodie. Ashley?
Thanks so much. And hi, everyone. I don't have a lot to add to what Ashwita has already very excellently summarized. I just one point on the conciliation annex. It is not really high up on the priority for the COP agenda, as you can imagine. The COP agenda is like fraught with a lot of other issues in conciliation annex. I'm not holding my breath. I should also preface my comments by saying that I will naturally take a more state-centric point of view to the discussion, but all the views that I expressed today will be mine and not representative of the government. So on the Article 6.2 Paris Agreement cooperation, yes, so we have, Singapore has been one of the first movers when it comes to signing these implementation agreements. And yes, so a lot of it has been in the last couple of years. So last year was 8 agreements actually. So it's a very new area, and it's designed to tackle a really real problem, which is that Singapore has committed to achieving net zero emissions by 2050. But as you would know, Singapore doesn't have much alternative energy. We have limited space for solar panels. You don't have geothermal energy. There's no hydroelectric energy. If you were to rely on the Singapore River to generate hydroelectric energy, we will all be sitting here in darkness. So it's designed to resolve a really real problem, and that's to make sure that we can still achieve net zero. We're going to reduce and mitigate emissions, but also we need to bring up our carbon credits balance. So I think another point that I will add on to what Ashwita said is that there's the state-to-state arbitration side of it. So the implementations provide for arbitration between states, but also many of the implementation agreements, we've gone one step further and negotiated for arbitration between private project developers as well as the host states. So with the intention of ensuring more certainty when it comes to investing in these green projects in other countries. And the final point is these implementations agreements don't necessarily have to go to Singapore companies. It can also be from anywhere. The idea is to profile Singapore as a carbon trading hub and also a hub for all these other ancillary services, including legal services. Yeah.
Thank you for the Singapore perspective on this. So the next topic is climate-related commercial arbitrations. So as climate change increasingly affects business operations, how have climate-related issues come up in international commercial arbitrations, and how have corporates responded to these developments as well as evolving risks? Reshma?
I'd say that this is basically what I hope is my bread and butter, right? I like that we talk about all these cases and the treaty aspects of it, but like Elodie said at the start of this, I think we tend to see a lot more of the commercial arbitrations of it. We just can't talk about it as openly, obviously. And so maybe I'll approach this question in the same way that sometimes we talk to our clients, which is when they sit up and go, well, how is this relevant to me? I'm a corporate. Unless an NGO is going to sue me, why should I be bothered with all of this or the trends of this? And maybe I'll, try and touch on a few topics or themes of that. So the first that I really like to bring up to these clients and make them sit up is to remind them that there's a risk of parent company liability. We see a lot of that in litigation. So you may know the Vedanta case that we acted on. There's the Okpabi case. Those are both in the UK courts. They don't stand for the proposition that parent companies will be liable for the harm that their subsidiaries cause, but they do accept the principle that in theory, you could bring a claim against them as a matter of jurisdiction. And that really just goes down to question of assumption of responsibility and control. And so when you look at it from a corporate's perspective, it is a big question for you as to how you're regulating certain arms of your business. How ring-fenced are they? How much has your board talked about them to, understand your liability? A second type of dispute that I think corporates are very much concerned with, and I don't think gets that much attention actually, is licensing delays. So you've got all your environmental impact assessments, your permits, whether it's a land permit to build a project, whether it's safety permits in the nuclear context, whatever it is, a lot of these permits are, especially if given by a government, facing a lot more scrutiny, which means that they're getting tied up in bureaucracy. And you could say, well, that's still a state to investor dispute. But actually, a lot of the times you've got party A that's warranted to party B that they will get those permits by the time of construction or by as a condition precedent. And so what then you have is a warranty claim between two corporates in commercial arbitration. And then maybe the third one that I think is very obvious to all of us is shareholder disputes. Let me tie those two things together. Why are there so many warranty claims? Why couldn't they decide how long it would take to get these permits? It's because we are, as much as it seems that we know everything now about solar and wind and nuclear, actually we don't. And there is a lot of learning on the go for not only science as a whole, but for a lot of producers who are trying to do this and get ahead of the transition curve. And for the same reason, therefore, there's a lot of tension between shareholders. So as a very obvious and simple example, I think we've now all seen how much volatility there is with offshore wind projects. At some point, it was the grand idea. Over the last year, maybe even 6 months, the economics of it is looking a lot shakier. You've got Trump coming out and saying he's not going to support any more offshore wind. And honestly, I do see shareholder disputes out of that. I mean, we're working on them where shareholders, party A, now no longer wants to be tied to this project and they're looking for any reason to get out. That is a transition dispute, even if they're not actively arguing, GHG emissions and tensions between shareholders as to how much they should save the earth. I'll just pause there, I think.
Thank you. Ashwita?
Yeah, sure. I think you can speak to the first part of your question, which is how climate issues have come up in commercial arbitrations. And I've understood the term commercial arbitrations in the broadest possible way. So not under treaties, not only involving states. And I could come up with two examples. The first is sort of in the world of climate finance, which, as you can imagine, addressing climate change requires the mobilization of a huge amount of finance. And the type of financing that comes in is just very diverse. There's public, private, blended, alternative, all kinds of financing for these sort of outcomes. And there's a huge number of actors that are engaged in the space as well. So you have like what you would understand as a traditional corporate, but there are also sovereign funds, private funds. There's a lot of work being done by traditional multilateral development banks, such as the World Bank, the ADB, as well as specific climate funds that have been created by UNFCCC, for instance, the Global Environmental Facility, as well as the Green Climate Fund. So these are specific funds that are created to work on climate change issues. And there are arbitration clauses in a number of the financing agreements that involve these entities in the context of financing. So if I just look at the Green Climate Fund, the Green Climate Fund has entered into agreements called contribution agreements with states. And the purpose of these agreements is to govern the terms by which states can provide financial contributions to the fund for its use, for its objectives. And the contribution agreements have arbitration clauses in them. So that's a good example of how you can have a commercial arbitration coming out of what is a financing agreement. The Green Climate Fund has also entered into accreditation agreements with, for example, multilateral banks. It has one with the Inter-American Development Bank. And the purpose of this is to basically disperse funds. So it's the way by which the funds that are held by that trust are then given to certain entities for the running of particular projects, and the agreement governs what kind of project it is, how those funds are dispersed, and so on and so forth. And those clauses, those agreements also have dispute resolution clauses that refer to arbitration. So that's another sort of avenue where there could be these commercial arbitrations arising. The second broad set of examples, to my mind, is in the voluntary carbon market. So we've talked a lot about like states' obligations to meet certain conditions and so on and so forth, but there's obviously a thriving voluntary carbon market where, which is driven by private demand to reduce emissions. And you would have heard of a lot of these certification standards like Verra and Gold Standard. I think these are the most widely recognized ones. And what these standards do is that they develop the processes and rules that govern the life cycle of certain projects. And that's how you know that these projects are actually achieving mitigation outcomes and so on and so forth. And there is a lot of contractual work around this certification process. For instance, early iteration of gold standards appeals processes did include PCA-administered arbitration, which meant that if there was a problem with that process and there was an appeal, then there would be an arbitration that resulted. So these are just a few examples I could think of climate-centered commercial arbitrations that could arise.
Thank you, Ashwita. So in relation to the initiation of legal proceedings on members of the board of directors or the management of a corporation, how does that typically take place in climate change disputes and in particular in international arbitration? Alain?
Yeah, when you ask me this question, I'm mainly thinking of one case which was not dealt in arbitration, but which could easily be dealt in arbitration, but actually was a litigation. And I'm not going to go into the details of this case, but I just found the arguments that the claimants were making very interesting, which was a case against Shell, which played out in London in 2023. It was, again, an NGO, Client Earth, was suing the board of directors of Shell. And the argument that they were making is very interesting because they said the board of directors of Shell put in place some climate change strategy based on which Shell was supposed to comply with the goals of the Paris Agreement over the years. And then the claimants took this climate change strategy, gave it to a scientist and said, have a look at it. And the scientist had a look at it and said, look, this is never going to fly. They will never achieve those goals. And then they went back to the board and said, we're going to sue you because what you did, actually, you breached your fiduciary duties because you did not set up the company to be in a good place in the future. We will be in a better place compared to our competitors because we will not be able to deal with the challenges of climate change in a proper way. And that will cause the share price to go down, and that will affect me as a shareholder, and that's why you breached your fiduciary duties, which I found is a rather interesting argument to make. And the court declined it in London. They said actually there is a certain amount of discretion that a board has to implement a corporate strategy and especially also a corporate climate strategy. And this, what they implemented, was still very well within this amount of discretion. And that's why they said they declined the argument. But the thought behind it was interesting to me because this is, in my logic, when I think about those cases, kind of the third wave of those cases. The first wave, in my view, is the cases that were brought against states to kind of try to influence the states, and then they were successful. Then they were trying to use the narrative and suit corporations to try to influence corporations. And when they were sometimes successful, sometimes no, they said, okay, let's start the third wave. Let's go against individual board members or member of the management, just to exert the maximum amount of pressure on a company to make sure that they're going to adapt somehow to the challenges of climate change.
Thank you, Alain. Reshma?
Well, I mean, same question, right? In relation to how do we deal with disputes or claims against directors? I actually thought it would be quite rare to have cases like Client Earth and Shell in arbitration, primarily because the derivative action is something that you would more normally bring in litigation, and also the kind of reputational point which you would lose in arbitration. But I think there is still liability for the boards for the same reasons that we were talking about earlier with, say, Okpabi, in terms of what they're putting into their board statements and annual reports. And I think I'll be remiss to kind of give a counterpoint to the Shell case, because just about 2 weeks ago, what's today's date? 17th of February is when there was a decision in Australia that came out on Santos. And I know about it very much because we work on it as well. It's a litigation case. And to give you basic context, the Australasian Corporate Responsibility Authority sued Santos for something very similar like what they had set up in the Shell case. Basically alleged that Santos' representations in their, I think, investor presentation, right, investor day presentation, which is similar to an AR, overreached, that it suggested that they were relying on clean energy, that they would meet their net zero targets by a certain year or by a certain percentage that wasn't really backed up by science yet. And the court has found that actually the statements were reasonable. And in the context of this question on directors, why I wanted to bring it up is because the court confirmed that why they found the statements reasonable is because they had enough evidence as to how the board had considered these questions. And they had enough paperwork to look at what the board had considered. And I think the word was critical in determining if the assumptions that they made were reasonable. I mean, it's a really interesting outcome because obviously from a climate activist perspective, it's not promoting pro-climate, right? Because if you found that Santos can say, you know, this is our climate plan. We know that the science doesn't exist yet, but we plan to move forward on that. But it really does come down to, well, what does the board think is reasonable? So I thought I'd just add that. Thank you.
Thank you. So I'd now like to turn to the landmark advisory opinions of the ICJ and ITLOS. So on 23rd July 2025, the ICJ rendered an advisory opinion on the obligations of states regarding climate change. It found that states have legal obligations under climate treaties, customary international law, and other applicable international law to carry out climate adaptation planning and implement adaptation actions in line with the best available science. On 21st May 2024, the International Tribunal for the Law of the Sea issued an advisory opinion confirming that the parties to the United Nations Convention on the Law of the Sea are obliged to take measures to combat marine pollution caused by climate change. What sorts of disputes do you foresee arising as a result of the findings in the ICJ and ITLOS opinions? And what sort of impact will these opinions have on the various stakeholders in international arbitration and other forms of dispute resolution? Ashley?
Thanks. Okay, I think I'll start by just highlighting a couple of useful points from both of the advisory opinions. I won't try to do a summary of several hundred pages in 2 minutes, so I won't. But for the ITLOS advisory opinion, I think one of the key points is that pollution of the marine environment does include greenhouse gas emissions, even though the United Nations Convention on the Law of the Sea was signed in 1982 when people didn't really know about climate change. But the definition of marine pollution is still flexible enough to accommodate new types of pollution, right? And so a lot of the findings made by the International Tribunal for the Law of the Sea would flow from that. For example, the obligation to prevent, reduce, and control marine pollution has to include greenhouse gas emissions. The obligation to protect and preserve the marine environment from marine pollution, that also includes greenhouse gas emissions. Also, a few others, well, not side obligations, but I'm not going to say ancillary because they are important as well. But other obligations include obligations relating to environmental impact assessments. Those may have to include analysis and assessments of greenhouse gas emissions. Also, the duty of among states to cooperate when it comes to reducing greenhouse gas emissions. On the ICJ advisory opinion, so the scope of that is a lot broader because it covers international law generally. So under customary international law, states have the obligation of stringent due diligence to ensure that significant harm is not caused to the environment, including through greenhouse gas emissions. But also it interpreted several obligations under the Paris Agreement, including the submission of nationally determined contributions. Those also have to be under the standard of strict due diligence when it comes to figuring out what you want to, each state is going to submit under those NDCs. Okay, so I think the points I would highlight are what the tribunals and courts have said about state responsibility and liability. For ITLOS, it wasn't part of the question, but the tribunal found it necessary to comment on some aspects of this. And essentially, the finding was that if a state is unable to respect its obligations that were identified, then state responsibility would be a natural consequence of those breaches. And the ICJ also made very similar findings. And ICJ went a little bit further and even mentioned if a state engages in certain fossil fuel production and consumption activities, those may create a source of state responsibility if it results in injuries to other states. So Those are the points I would just highlight for the purposes of this discussion. All right, and also, okay. So yeah, okay. So I think these points might inspire interstate litigation. So far it's just been advisory proceedings, but there's always the question of what next now that the court has articulated all of these obligations very clearly. So with the obviously with the ICJ, there's the question of jurisdiction, how you're going to get states before the ICJ. But with ITLOS, there's always the possibility of arbitration, compulsory and binding dispute arbitration under Annex 7 of UNCLOS. So that remains a very possible way for states to bring their disputes before ITLOS, before the arbitrations under arbitral tribunals under UNCLOS. Yeah. The other point I would just comment on is states referencing these advisory opinions to justify certain actions that they take, regulatory actions, for example, if they want to undertake certain green or climate-friendly policies. But on the other hand, they're concerned that these measures that they're taking might fall afoul of other international obligations, such as investment treaty obligations. There's a question as to whether or not they could, how much and what the extent they could rely on those obligations to justify those measures. And so it's still an open question. We haven't really seen any arbitration or any international case where those arguments have really fully been advanced, but it's definitely a space to watch.
Thank you for these great insights. Our next question is also for you, which is, how are states responding to the current developments in climate change? And can you please elaborate on your work in this space?
Yeah. So there's been a very wide range of responses to the ICJ advisory opinion. I think the ITLOS advisory opinion states generally it wasn't super adventurous. So I think states generally were quite it was received fairly positively, but you will see a fairly wide range of responses to the ICJ advisory opinion. On one hand, you have states like Vanuatu and many other small island developing states like Singapore, which welcomed the opinion and are pursuing they're negotiating for a certain resolution to be put before the UN General Assembly, welcoming that advisory opinion. On the other hand, you have the US, for example, which has withdrawn from the Paris Agreement and also announced its intention to withdraw from the UN Framework Convention on Climate Change, as well as other oil-producing countries. For these countries, there is a view that the ICJ advisory opinion may have been a little bit adventurous when it comes to interpreting certain obligations and provisions under the Paris Agreement, most notably the provision on the temperature goal in Article 2 of the Paris Agreement. So just for context, the Article 2 mentions there's two parts to it. The first part is on a 2-degree temperature goal and also pursuing efforts to limit global average temperature to 1.5 degrees. The International Court of Justice interpreted subsequent decisions of the Conference of Parties to mean that parties have, in fact, recognized that 1.5 degrees is actually the scientifically proven or recognized standard or aim that is under the Paris Agreement. So just some of that. So there's been lots of pushback on various fora, including, you might have heard about the International Maritime Organization in the US, basically rejecting the net zero framework under the IMO. So these are just examples of how broad the whole spectrum of responses has been. But I do think that it's really also really encouraging that states are also finding ways to ensure that they can mitigate their carbon emissions and also adapt to the adverse effects of climate change. I think, Reshma, you've also mentioned the impact on investment treaty arbitrations and negotiations of these bilateral investment treaties. So there's also a lot of work ongoing in terms of how to amend or update some of these treaties to make sure that states are able to undertake climate-friendly policies. But this, I think, is a process that will have to go on for some time.
Thank you for that. So finally, we would be grateful for your advice for junior lawyers keen to develop a practice in climate change disputes in the future. So Elodie, we'll start with you.
Thanks. I think the good news is that it's quite a new field, which is going to be evolving. So you're not coming with people who have been doing it for 30 years. It's really good for you to get your foot through the door. And I think one is educating yourself, about the regulatory framework. I mean, the treaties. I mean, knowing what's out there, and probably in a number of countries, you may have an interest in looking at what's going on, because there is going to be more and more regulation. And if you have more regulation, you're likely to have more disputes. So it's just being very basically proactive and anticipating, building the knowledge and anticipating and watching out for, it's not ambulance chasing, but you have to watch out for where the disputes are going to arise, because it's really evolving, and you're kind of on par with others in terms of looking at what may be next. So it's really an opportunity.
Thank you. Ashwita?
Oh, yeah, sure, I can go next. I think that there's a lot of interaction between different levels of regulation. I think there's a lot happening in the international, interstate, multilateral space. There's a lot happening regionally. There's quite a lot happening domestically, sometimes because of what's happening regionally or internationally. So I think it's worthwhile to spend some time thinking about how those different regulatory regimes interact and how they influence each other, because that will become relevant, I think, as everything starts to come together in coming decades. Yeah,
that makes sense. Thank you. Ashley, grateful for.
Yeah, well, like Elodie mentioned, it's a very new area, so you don't have to worry about your more senior colleagues having tons of experience on this area. It's really a great opportunity to get your feet wet and go into it. There's so many facets to climate disputes or climate change law that I feel like, and this area is only going to continue to grow. So it's so many opportunities.
Thank you, Alain.
Yeah, I think I can only emphasize what we have heard before. It's such a broad and diverse field. And I think my advice to you would be, if you want to practice in this area, don't just narrowly focus only on the dispute side. You also have to be interested and deepen your knowledge in certain other areas like climate change science, international agreements, corporate responsibility, or just general environmental rights. And to be able to get a broad understanding of the field in general. That would be my advice.
Thank you. Reshma?
I don't think I could add anything more. Maybe we should congratulate all of you for being here, because you're obviously interested and open to learning. I also see some of my students, so thank you. Exactly as everybody said, new space, absolutely yours to make what you want of it. It's also an evolving space, so it's also quite difficult at times to keep up with it. But, grab the opportunity and run with it, I think.
Thank you. So I'd now like to open the floor to the audience. So if you have questions for our stellar panelists, now is the time to pose them. Okay, we have a question there.
Thank you. Thomas Lehman, research fellow at NUS, working also on this type of topic. There is one type of climate-related dispute that we haven't mentioned, and it's not under BATs, it's not under investment treaties or in commercial contracts, it's investment contracts. So we know that Total, Shell, BP, etc., they conclude agreements with developing states in which they have a contract and an arbitration clause, sometimes referring to the PCA, sometimes referring to the ICC. And these clauses provide for a freeze of environmental regulations or freeze of fiscal policy applicable to the investment, sometimes for 20 years, sometimes for 30 years, sometimes for the duration of the project. So I just wanted to have your views and perhaps your experience with certain of these cases that have maybe appeared before the PCA, or maybe Elodie has some experience of these investment contracts related to climate that have already come and arisen. Perhaps Elodie, if you, and then Ashwita.
So I haven't had the experience with a climate-specific issue, but with this, I've had the experience of like these state contracts, and one difficulty, and with stabilization clauses, one tension you always run into is that the law governing the contract is likely to be the law of the host state, and then you are going to have a new mandatory law. And then there's a question about how enforceable your stabilization clause is. With that uncertainty, I think that's where you see sometimes parallel proceedings, BIT proceedings, where it may be that you have to go to BIT arbitration if actually you would have an issue with the enforcing your stabilization clause. And then your stabilization clause, especially if there is an umbrella clause in the treaty, will give a further ground to bring a treaty claim.
Yeah, thanks for that question. I don't think I can speak to a specific dispute that's arisen of that nature, but what I can say is more broadly, there seems to be a greater interest in regulating relationships that might have previously been regulated by investment treaties, by now regulating them by contract. And I think that's part of a broader trend. I think even in Working Group 3, there's been this focus on how can we move away, commercialize, so to speak, some of these relationships, because that might deal with some of the concerns that are being raised about investment treaty arbitration. And I can say that in the PCA's own caseload, although we do have a vast number of investor state cases, we also have a huge number of contract-based cases, and that number is increasing at a higher rate than treaty-based cases, which I guess if one was to just make a general observation, suggests that there may be more cases of the kind that you're speaking about than the kind of investor state cases we've seen previously, and they may deal with things that previously were traditionally investor state type material. But yeah.
So if there are no further questions, we have one at the back actually.
Hi, thank you to the panel for the very insightful discussion. I'm Jia Xin. I'm from MTI, so that's the Ministry of Trade and Industry, and I work on the investments desk. So we deal very heavily with the treaties that Singapore has with our counterparts. So I'm very curious to understand from the panel, because as mentioned, we have this current trend of the international investments agreements to have like a tightening of the FETs or FPS or even specific environmental carve-outs from the treaties. So what do you envision or foresee when Singapore is navigating or we are negotiating with our counterparts, especially in terms of like multilateral treaties? Do you think it would contain such provisions of environmental cover-outs, because everyone has a different play at the table? So what do you think that would look like in the future? Yeah, thank you.
I don't know if you want to hear from me, because you can hear from me anytime. But okay, I guess it really depends on what the negotiation dynamic is in the specific set of parties that are involved, right? So each party generally comes to the table with their own interests. One party might want to ensure that their investors are protected from, any expropriation type of actions or FET type of breaches. The other state might want to make sure that they are free to regulate as much as possible when it comes to climate. So it's really hard. It's a very hard, and I really just think it comes down to negotiation and what the balance of interests is. I still don't have a sense of what the general trajectory of how this BIT type of reforms are going to go. So I will just stay tuned. Yeah.
Thank you. Any other questions? Okay, so if there are no further questions, I'd now like to draw the panel discussion to a close. Thank you very much again to our wonderful panelists for their valuable insights and time. Thank you to you all for coming as well today. And we would again like to extend our appreciation to Herbert Smith, Freehills, Kramer, Prolegis Alliance for sponsoring this event. And we hope to see you at a future SGBAP event. For those who are here in person, please join us for a cocktail reception where we can continue the conversation. Thank you again.